So let's get started. What kind of cases do we have this month?
Well, I'm making this a de facto show only about the last month's positive immigration decisions, and it won't always be all of the positive ones, but certainly only positive ones, because why talk about the negative? There's too much of that anyway. And so this month, there was actually a lot of interesting stuff in the crimmigration area, and I'm not going to get too in the weeds on it. Obviously, I do that on my podcast, but it's important to highlight. And I want to highlight the fact that the first one is coming from the Supreme Court, when the Supreme Court did so much that I personally don't agree with this term and just last month, to be honest with you, including in immigration. I mean, the last month was so heavy for the Supreme Court. But the one decision that it did issue that would benefit non-citizens, including permitting the Biden administration to terminate MPP, is United States v. Taylor, which actually isn't in the immigration context at all. But it's in the categorical approach for the Armed Career Criminal Act context, which quite frankly sometimes comes up with the most favorable law for non-citizens, because the ACCA applies to citizens usually, and it seems that there's sometimes more empathy in that context. But it's the same categorical approach. Case after case has made that clear. So what the Supreme Court and circuits, but especially the Supreme Court, says in the ACCA context, very important to immigration. And what they said in United States v. Taylor is that attempted Hobbs Act robbery, which is federal robbery with a gun, I'm pretty sure, attempted Hobbs Act robbery is not a crime of violence because it's an attempt. It's not violent. There's no violent force with just an attempt, at least at the federal law, because what is required, and I think it's a significant step, is the substantial step is what is required to get an attempt conviction. So a substantial step towards robbery, that substantial step under federal law, it doesn't have to be violent. It's not even close. I think Justice Gorsuch was talking, and Justice Breyer were talking about a hypothetical where the person walks into a bank with like a letter that says your money or your life, and they get caught by the cops before anybody even knows what's going on. Yeah. That's a substantial step, but it's not violent. And I have a feeling that most states have similar requirements for an attempt type crime. So to me, United States v. Taylor seems to make it very difficult, if not impossible, for attempt crimes to be crimes of violence, aggravated felonies, which also would then potentially take them out of crimes of domestic violence, removable offenses, an attempt, because it doesn't require violent force. Now, there's a caveat in immigration law, because 101A43U makes an attempt to commit an aggravated felony itself. And so I'd have to look more into that. But it's a big deal. And honestly, the government made the argument, and Supreme Court conceded it. Like, all of this, it was supposed to be a different statute that attempts would become crimes of violence. But the Supreme Court has found all those statutes unconstitutional, including in the immigration context. Sessions v. DiMaia many years ago on 18 U.S.C. Section 16B. So point is that attempts to commit a crime of violence are probably not crimes of violence in almost every state after United States v. Taylor. And oh, by the way, the Second Circuit said as much in USA v. Castillo a week or two beforehand. So 2 cases this month, although Castillo's a bit irrelevant now because the Supreme Court spoke 2 weeks afterwards.